Hello and a warm welcome to all on our special program Current Affairs. Recently, the government has notified new e-commerce rules, namely the Consumer Protection E-commerce Rules 2020. These rules have been issued by the Ministry of Consumer Affairs, Food and Public Distribution under the Consumer Protection Act 2019. Some experts have pointed out a few issues with the new e-commerce rules. In GK Today's Current Affairs Explainer program series, we will discuss questions like what are the major provisions of the new rule, what does the new rule seek to achieve, issues with these new rules, restrictions in investment due to e-commerce rules, and also we will know about the way ahead. To begin with, let us first focus on the first question: what are the major provisions of the new rule? At present, the e-commerce rules recognize two e-commerce business models, namely marketplace model and inventory-based model. The rules have separate specified provisions for marketplace and inventory-based entities. The e-commerce players will have to mention the total price of goods and services offered for sale along with breakup of other charges. It is also required for them to indicate the expiry date of goods offered for sale and the country of origin of goods and services. E-commerce players have to display details about return, refund, exchange, warranty and guarantee delivery and shipment and any other information that may be required by consumers to make informed decisions. E-commerce companies should not impose cancellation charges on consumers. The new rules are applicable to all e-retailers registered in India or abroad, but providing goods and services to Indian consumers. The violation of the rules will attract penal action under the Consumer Protection Act 2019. Moving further, let us know what does the new rule seek to achieve. Mentioning the name of the country of origin is significant as India and many other countries are presently renegotiating their free trade agreements. The new rules forbid unfair trade practices by entities and sellers on marketplaces and manipulate the price. That means the entities are not allowed to gain unreasonable profit by charging unjustified prices. Moving further, let us know what are the issues with these new rules. Though the provisions are intended as safeguards that ensure a level playing field, some of these provisions are impractical. Applying identical rules for big and small business players does not convey a business-friendly approach. There is no clear definition regarding what would constitute price manipulation. It also remains vague how the e-commerce entities and sellers are supposed to navigate these roadblocks without falling foul of such provisions. It is mandatory for both the marketplace entity and sellers to establish a grievance redressal mechanism, but small businesses may not be in a position to comply. The rules also prohibit an e-commerce entity from levying a charge for cancellation post-confirmation. What are the restrictions in investment due to e-commerce rules? The Foreign Exchange Management Rules 2019 presently recognizes the marketplace and inventory model. It permits 100% FDI under the automatic route to marketplace entities as also to those engaged in single-brand retail. Foreign investments up to 51% are permitted in multi-brand retail with prior government approval. According to the non-debt rules, entities involved in single-brand retail are allowed to carry out retail trading through e-commerce. However, single-brand retail trading through e-commerce has to set up a brick-and-mortar store within 2 years from the date it starts online retail. Retail trading in any form through e-commerce is not allowable for entities involved in inventory-based multi-brand retail trading and having foreign investment. Lastly, let us know the way ahead. Because brick-and-mortar operations may not be possible in the foreseeable future, the commercial sector is expecting from India to consider relaxing some of the e-commerce rules or extending the time period for compliance. There needs to be resort for some practical provision. One-size-fits-all notion should be done away with. There should be a clear definition regarding what would constitute price manipulation.